use ESG in pension funds investment management. 12 state agricultural heads are probing the credit access for farmers and ag product manufacturers by the Net Zero Banking Alliance. Achieving net zero allegedly required targets set forth for steel, automotive, and aviation industries as well. Allegations on block credit for oil and removal of board members from Exxon who could not sign on to climate targets. But all those banks and all those investment companies have left the Net Zero Banking Alliance within just a few months, weeks, and days. And to quote the Banking Alliance, the reason was due to different regulatory and client expectations in investors' respective jurisdictions. They have removed their signatures from the website, as well as climate targets and related case studies. So what changed? Well, for one thing, antitrust lawsuits from Texas, which Wyoming is part of, alleging fund activities cutting coal production and raising energy costs, pressuring coal companies for change, the suit alleges, defendants' investment in 9 coal companies. The lawsuit alleges BlackRock of falsely deceiving investors about its non-ESG funds by promising to dedicate them to enhance shareholder value when it allegedly used all of its holdings to advance its climate goals. The lawsuit, which Wyoming is a plaintiff of, seeks to block BlackRock, State Street, and Vanguard from using their investments to vote on shareholder resolutions and to take other steps that could undermine coal output and limit market competition. So this is the Texas versus BlackRock lawsuit going on now. The incoming Federal Trade Commission has promised to make it a priority to prosecute ESG. Indiana has filed 54 counts of alleged securities violations with their public retirement system with contradiction non-ESG funds. And finally, last week, American Airlines Pension Fund was found to have violated the law by making investment decisions using criteria other than the interest in the plans of its beneficiaries. The pension fund managed by BlackRock using environmental and social governance principles rather than financial performance to guide their investments. We have in Wyoming an excellent treasurer. Our pension fund managers are absolutely top-notch and are looking for the best possible returns. But the question remains, has Wyoming been the victim of ESG or the use of supposed non-ESG funds used to affect fossil fuel markets or social agendas rather than a simple rate of return? That has yet to be answered. Have we been a victim to the climate cartel in coal production and pricing? That remains to be seen in our litigation. But one thing is certain, this bill helps our managers to safeguard our investments and get the best return following our fiduciary responsibilities under the law and help to bring Wyoming into a prosperous future. With that, I can go through the bill.
Yes. Please proceed, Representative.
So this bill is an act to the administration of government specifying requirements for the hiring and retention of investment managers, trustees, and fiduciaries who invest state funds as specified, specifying proxy voting requirements for investment managers, trustees, and fiduciaries who invest in state funds, providing definitions, making conforming amendments, and specifying applicability and providing for an effective date. So the first thing we find on the end of page 1 is a created portion, which involves the investment of state funds and consideration only for financial purposes. Page 2 goes into the definitions of that with fiduciary commitment, advertising statements, the affiliation or status as a signatory. Page 3 further defines financial shall not include any section taken or factor considered by a fiduciary or trustee with any purpose whatsoever to further social, political, or ideological interests. The fiduciary may reasonably be determined to have taken an action or considered a factor with a purpose to further social, political, and ideological interests based upon evidence showing a fiduciary commitment. Further down, it goes through what those actions would be: eliminating, reducing, offsetting, or disclosing greenhouse gas emissions, instituting or assessing corporate board or employment composition, compensation, or disclosure criteria that incorporates characteristics protected in the state as specified, divesting from limiting investments or limiting activities of investments of a company, for failing or not committing to meet environmental standards or disclosures. D is providing an increasing access to abortion, sex or gender changes, transgender surgery or treatment or procedure that could violate the statute. Divesting from, limiting investments or limiting activities of a company that engages in, facilitates, or supports the manufacture, import, distribution, marketing, advertising, sale, or lawful use of firearms, ammunition, components, parts, or accessories of firearms and ammunitions. So those things do cover other social issues, because ESG is not just involving energy. ESG can involve social issues, and the point of the bill is to prevent any future activity with that. When you invest funds, it is strictly on a financial basis, and no other factors should be considered when investing. The next page, 5, in making and supervising investments of state funds, each investment entity shall discharge its investment duties solely in the financial interests of the beneficiaries of the applicable state funds for the exclusive purposes of providing financial benefits to the beneficiaries of state funds, defraying reasonable expenses, administering the investment of state funds, meeting other purposes required by law, and not relating to the actions and considerations prohibited by this section. Any person or fiduciary designed as a custodian of the state funds, or any person or fiduciary assigned to invest state funds, shall be subject to the same fiduciary duties as an investment entity under this section. Each fiduciary shall take into account only financial factors when discharging his duties in investing state funds. All shares of stock held directly or indirectly on behalf of an investment entity or on behalf of the investment entity's beneficiaries shall be voted solely in the financial interest of the beneficiaries. Proxy voting is a great concern as well. On page 6, at the very bottom, the investment entity shall not grant proxy voting authority to any person who is not part of the investment entity or who is not employed by the investment entity, except that the investment entity shall grant proxy voting authority to a person who has made practice of or commits in writing to following the guidelines that match the investment entity's obligation to act solely upon financial factors. State funds shall not be entrusted to a fiduciary unless the fiduciary has a practice of and commits in writing to following guidelines which engage in the portfolio of companies and voting shares of proxies that match investment obligation to solely upon financial factors as required by this section. No fiduciary shall adopt a practice of following the recommendations of a proxy advisor or other provider unless the advisor or service provider has a practice of and commits to in writing following proxy voting guidelines that match the investment entity's obligation to solely act upon financial factors as required by this action. All proxy votes shall be tabulated and reported annually by the investment entity not later than September 1st of each year. For each vote, the report shall contain a vote caption, the plan's vote, the recommendation of the company management, and if applicable, the proxy's advisor recommendation. Each report prepared under this subsection shall be posted on the investments entity website. On page 8, the Attorney General may enforce any violation of this section if the Attorney General believes that a person has engaged in or is engaging in a violation of this section. The Attorney General may require the person to file a statement or report in writing under oath as to all of the facts and circumstances concerning the violation and to provide any other data and information deemed necessary. In addition to the other remedies available at law, any person who serves as a fiduciary and who violates this section shall be liable for damages to the investment entity in the amount equal to 3 times the amount paid to the person by the board for the person's services. All accounts collected under this subsection shall be deposited into an applicable state fund against which the violation was committed. Section 2 is conforming statutes amended. On page 9, in addition to any other duties prescribed by law, the board shall serve as an investment trustee of the funds of the system. In serving as an investment trustee under this paragraph, the board shall apply with the requirements of the added statute. The board or its designee shall be required under the Investment Advisors Act of 1940 as amended, or a bank is defined upon written authority shall invest monies in the retirement account, which investments shall not be considered disbursements for purposes and subsection of this section. So we've added in every section going forward here, that subsection that we've placed in the beginning, which requires those sections that can't be used with ESG. And with that, I would take questions.
Thank you, Representative Knapp. Committee, any questions for the representative on this? Representative Larson, excuse me.
Thank you, Mr. Chairman, and thank you, Representative Knapp, for presenting this bill to us. So can you just walk me through a scenario? Okay, I'm the manager, and there's company X. They've decided that they want to not only comply with federal and state law on emissions and those sorts of things, but they voluntarily, because they want to sell to their customers, decide they want to up their standards. How does this apply to our managers on investing in those types of companies?
Representative Larson.
Representative Knapp.
Oh, I'm sorry. Thank you, Mr. Chairman. Representative Larson, could you define up their standards for me?
Representative Larson, clarification.
Thank you, Mr. Chairman. I think, they decide to implement a technology that is more efficient than required to reduce emissions, just for example. That could not be the only example, but for example, that they decide they want to buy a piece of equipment that reduces the emissions more than that is required.
Representative Knapp.
Mr. Chairman, thank you. Representative, if you think about the investment, we're looking at a rate of return. So investing in new technologies and things like that could, in essence, get you a better return on your fund. It's when you have a stated goal or a stated social goal or a stated energy policy goal that is more political and more shaped towards an environmental goal at the end. So technologies and things like that, I do believe would be fine under this bill. Those are things that enhance companies and bring extra value to an investment.
Follow up. Representative Riggins and then Representative Lawley.
Thank you, Mr. Chairman. I suspect it's virtually almost impossible to divest ourselves from every element of ESG in 1,000 mutual funds that are sitting out there, et cetera, and every other investment. So when I look at this, and you can tell me if our goal is right or wrong, there are certainly portfolios that are expressly ESG. Vanguard has one. I think there's 5 or 6 mutual funds in it. And they expressly put in their summaries, coal, gas, oil, emissions. I mean, it's prominent. Now, many of these funds, to me, have laudable things at the top of the page I found interesting. And they put those right at the very bottom of their summary. So I don't think it's impossible to simply, hey, we're not gonna invest in those specific portfolios that is their stated goal. I don't think it's possible. You can't, I read an example of what it would look like. And I would love to share that if I'd been sitting over there, but in the opposition. But what do you think on that? That's the only avenue I could see that's practical, is that just have to isolate those specific portfolios.
Chairman, I believe there's a question there.
Mr. Chairman, thank you. Representative Riggins, I believe you're correct. I think that most companies today do have a stated ESG document. And it's usually listed right at the, like you said, right at the introduction of their company. They have usually laid out what they've done. And so I think those are easily identifiable. There's other companies that are actually moving away from that and scrubbing that off their corporate documents. I think the sign of the times and the change of administration has led many to realize where the profits will be in the next 4 years. And so you'll find that a lot of companies are removing that and actually changing directions in their ESG platform. Thank you.
Follow-up? Representative Riggins, any follow-up? Okay. Representative Lawley.
Thank you, Mr. Chairman. Representative Knapp, good to see you over there. It's always good to see you over here, too. But I want to focus in, and maybe it follows up a little bit with Representative Riggins' comments, but on the practically walking through, how does this work? So Representative Riggins gave a good example of an easy one. There's a policy, it's written, it's clear, and it clearly would violate this. But let me ask you in one particular area to get an idea of some of what my concerns are. On page 4, lines 4 through 7, I'm wondering how far we would go with that. What would be the requirement of our investors? Would they need to, for example, investigate everyone's employee benefits of insurance, and if they included some of these things as coverage in their insurance, would they now be, I mean, what level would our investors have to go to basically assure themselves that they would be qualifying under this provision? I'm kind of worried about a chilling effect and even a practical thing that gets a little more interesting than already stated policies about the environment, et cetera. So can you help me with that, how that would practically work in that particular area?
Chairman Knapp.
Mr. Chairman, thank you, Representative Lawley. I think that would work in the same fashion. Typically, obviously, as an investor with the state, you're not going to dive into minute details of a corporation or individuals. I think that typically a corporation or a financial institution that does deal with, because like Representative Riggins mentioned, typically you have different segments of investment portfolios and different options. And so if you're looking at a corporation or a financial institution that does as you mentioned, from lines 4 to 7, deal with transgender surgery or gender changes, it's going to be pretty present in their documentation for that particular fund. So those are the social issues that stand out, and I think it's almost impossible to dive deeper than that with those types of things. But those particular funds, whether it's guns or whether it's that type of social issue, are going to have that stated in their documentation.
Follow-up?
Thank you, Mr. Chairman. Representative Knapp, how would you describe or give me an example of or describe this phrase, providing or increasing access to? What does that look like in your mind?
Representative Knapp.
The providing or increase, oh, I'm sorry, Mr. Chairman. Representative Lawley. I don't know. I don't know how that would be stated necessarily with a corporation in looking at that. But again, I would say it has to be a goal or a written statement with that portfolio. And I know that would be pretty rare, I would imagine.
One more follow-up.
Follow-up?
Thank you, Mr.
Representative
Chairman. And I kind of agree with you that it would be rare and maybe hard to determine. And what I think I hear you saying, and correct me, is that it would need to be, when you say goal, you use the term goal, the goal of that particular investment group or that particular corporation to provide or increase access to these things. Is that your understanding of how this would kind of apply or should be interpreted?
Representative Knapp.
Mr. Chairman, Representative Lawley, that's correct. I believe that if it's a stated written goal within their corporate documentation, that would be easy to see. But other than that, you wouldn't know.
So Representative Knapp, just for clarification for my part, you mentioned it if it's a stated goal, but if a company is providing these kind of benefits to its employees through a health insurance program, would that apply to paragraph D that is being referenced here? If they're providing that coverage through their own employees through health insurance?
Mr. Chairman, I don't believe that would fit into this category. I do believe that it would be stated goal of that entity to the public versus its own internal employees.
All right, thank you. Representative Lawley.
Thank you, Mr. Chairman. I appreciate your interpretation of this, but would you be open to perhaps a friendly amendment that would kind of make that more clear? That
Mr.
would
Chairman.
make it more clear, no kind of, I take the kind of.
Representative Knapp.
Mr. Chairman, Representative Lawley, absolutely. If that would help with the bill to further define that as a corporate goal, stated goal versus internal, yes.
Okay, over here now. Okay. Representative Campbell, please.
Thank you, Mr. Chair. Thank you, Representative Knapp. I just want to go back in time and kind of get a holistic look at this to make sure I'm looking at this correct. ESG stands for Environmental Social Governance, right?
Mr. Chairman.
Mr. Chair?
Representative Knapp.
Mr. Chairman, yes, Representative Campbell, that is correct.
Mr. Chairman, Representative Knapp.
Campbell, follow-up?
Yes, that is a United Nations program, is it? The United Nations is an unelected foreign organization, but I believe that they are the parent of that, and that this ESG is a part of their Department of Economic and Social Affairs for Sustainable Development.
Representative Knapp, do you care to touch that one?
Mr. Chairman, Representative Campbell, yes, United Nations is one of the backers of ESG policy. There are others, but that particular fund that I mentioned that they have for asset management is under UN accreditation, I would say.
Representative Campbell, follow-up?
No further follow-ups. Thank you, Mr. Chairman. Thank you, Mr. Knapp.
Any over here? Okay, back to Representative Larson.
Thank you, Mr. Chairman. So the way that now I'm kind of putting this together and understanding it is, you know, and this will probably just be a yes or a no from you by the time I set it all up, but all we really care about at this point with this bill is what they say in their investment policy. We don't care about what they actually do. So let's say somebody or a company or an investment portfolio decides, well, okay, we'll just comply with the law and take it out of our policy, but we're still gonna invest in the same types of funds or companies. But on the surface, they take their policy out, then technically we're in compliance, but they are still, you know, they still have an underlying goal, even though it's not sent out to the public. So just walk me through that. How does this bill, are there any protections for that situation in the bill?
Representative Knapp.
Mr. Chairman, Representative Larson, this won't be a yes or no. But ESG, so and corporations can state this, they can have ESG goals, and then they can have a non-ESG fund. It's our responsibility to make sure that fiduciarily we are investing in companies that have no stated social goal in our investment. One of the issues that's occurring and where you'll find much of the litigation going on today is that there's a misrepresentation with those corporations of having a non-ESG fund, but actually using that fund to promote ESG goals. And that would violate the law. So I hope that answers that question. A corporation can still have a non-ESG fund, but actually be actively using that fund for ESG purposes.
Any follow-up? Representative Riggins.
Thank you, Mr. Chairman. Representative Knapp, would it be an expectation to have our investment staff go through each of the mutual fund portfolios to see and research every one of their holdings to see if one company in that group isn't one of the offending companies with an ESG policy? Would there be that expectation? Thank you, Mr.
Representative Knapp.
Chairman.
Mr. Chairman, Representative Riggins, I believe that we should do our due diligence in our investments. Part of that is sometimes you may have a management group that you're working with that are familiar with those funds, that recommend those funds. And I do believe that it is within our rights and our responsibility to our employees and our investments and to the taxpayers to make sure that those funds that we're investing in are not socially active and have that as part of their investment guideline. And not just because we prefer that, but that's the law. That's a federal law. So I think we comply with that and make sure that our fiduciary responsibility is related to finances only and no social issues.
Follow-up, Representative Riggins.
Thank you, Mr. Chairman. And I don't know, we'll find out shortly, I hope, what our general portfolios look like as individual equities. I don't think that you would find a mutual fund that you can invest in without stripping out one of those entities from it. So that would severely limit, I would think, our options. And so I just wanted to highlight that, and so I look forward to hearing additional testimony with expertise. Thank you, Chairman.
Was there a question there? Okay. Representative Lawley.
Thank you, Mr. Chairman. You mentioned during your presentation that we've made money on our investments, we've done well, but it may have in some way cost us in our own energy area. Do you have any data on that? Any information about how much we might have done that, and how is that connection directly to Wyoming? Is it to those industries in general? Could you just give me some information that leads you to that conclusion?
Representative Knapp.
Mr. Chairman, thank you. Representative Lawley, I wish I did have that information. In looking at the fiscal note, as you probably all noticed, we would take a significant hit in divesting ourselves, let's say, for instance, from BlackRock. BlackRock has historically given us a little bit higher returns than other funds. However, as our lawsuit, it would indicate, if true, and coal prices were manipulated, the amount of revenue lost to this state in revenue from extraction would be far greater than the revenue lost in divesting from that organization. And again, our fund managers in Wyoming and for the state have been excellent in their selections. I think this recent activity with antitrust laws, the recent activity with non-ESG funds actually turning out to be ESG funds, and almost a disinformation of those portfolios, sometimes can't be foreseen. And we invest long-term in most of those capacities, and it would take time to divest from those. But the amount of revenue lost, again, if our lawsuit bears information out, is far, far greater than any loss we would receive in those extra percentages of income.
Follow-up.
Thank you, Mr. Chairman. Representative Knapp, so what I'm hearing is there's not really been any sort of financial analysis on that. We have the lawsuit and the allegations there, which may be true, but there's not really been someone that's done an analysis on how much, whether how we may have adversely affected our coal and oil and gas industry in terms of dollars through the investments versus what we made. I mean, that's kind of what you talked about. So I just want to, as far as you know, there's no real financial analysis on that as it relates to Wyoming, the state of Wyoming.
Representative Knapp.
Mr. Chairman, Representative Lawley, there is not currently. It actually would be fairly, I think it would be easy to do going back. These allegations are clear back to 2021. And so if you looked at that typical production and what was limited in production, some of those are hard to see. For instance, capital for small oil and gas companies looking for investment in drilling, and that being purposely shut off. Again, I think there's so many levels of where this could have affected Wyoming. It could be far-ranging, but could be calculated.
Representative Knapp, I've got a couple of questions to follow up on that train of thought. We have some long-term investments as a state that, and you mentioned this already, that if this were enacted, there's a fear that we would have to divest of those long-term investments and essentially take a haircut and lose some of our investment. But referring to page 13 on section 3, it says, "Nothing in this act shall be construed to impair or otherwise modify any contract that's already entered into." So as I interpret that, does this say that those investments that have already been made out there that may be long-term can stay until their expiration date? But any new investments have to follow this policy. So does this mean that we don't have to take a haircut? We can just let those investments already entered into continue until they expire? I just want some explanation on that section 3, please.
Mr. Chairman, you're correct. Any investment that we're already, because some of our investments, as you mentioned, are long-term in order to get those returns that we receive. Those funds, knowing that your money is going to sit there longer, give you that better rate. And so that does cover any investments that we would have currently that are contractually obligated, I would say. The other part of that too is these companies are changing very rapidly. I think that, like we mentioned before, the change in administration, the fact that antitrust is being mentioned, have these companies reversing themselves very quickly, getting out of the fund that they were in with the UN. So I do think that going forward, some of our investments that may be questionable with companies now may actually reverse themselves, fortunately. And that section does cover keeping those investments for that longer term
Okay.
that are currently in place.
Thank you, Representative. My last question is on page 3. This state is fundamentally based on our natural resources, and we work very closely with some oil and gas companies, some coal companies, natural resource exploitation companies that we rely on heavily. As I read this about a financial and a fiduciary, section A, subparagraph A on line 13 through 15, it says, any company that's involved in eliminating, reducing, offsetting, or disclosing greenhouse gas emissions. Now, a lot of these oil companies are involved in doing that. They're trying to reduce their emissions, and it's on their webpage. They're doing a lot of things to be able to reduce emissions as part of good corporate structure. So would this policy as written here in this draft, would that prevent us from being able to invest in large oil companies that are actively trying to reduce their emissions?
Mr. Chairman, I would say if it is a fund that has that as a specific goal socially or environmentally, it would be questionable as far as how far that company is going to do that. Obviously, every company is working to reduce emissions, I think, in what they perform and the services that they do. But if it is a stated corporate goal and that goal supersedes financial benefit to the state, and again, some companies will have that, but the funds that we invest in, if they use that as a measure, that's when it becomes an issue. When you and ESG is typically pointed, but when they have that in their documentation and it's used as a measure for a fund, I think that becomes a problem because you're using something other than your return on investment versus a social aspect.
All right, any further questions for Representative Knapp before we move on to other testimony? Seeing none, you want to return up here? Or you want-
Sure. Yes, thank you, Mr. Chairman.
All right, we'll open it up to other elected officials. We'll start at the top with our state treasurer.
We had, when it failed to get through the House, our office, on us, put an ESG policy in.
You know, Indian giver?
And this is
Treasurer, would you state your name for the record,
State
please?
Treasurer Kurt Meyer, happy to be here. We have already taken the bull by the horn, so to speak, and we've, for over a year, have had an environmental, social, and governance policy. And it's been on our website for quite some time. And we've also had proxies. We've implemented those last year. We've changed the protocols with an outfit called Boyer. And they're, I would say, the preeminent conservative proxy manager in the country. So the proxy thing, I think, has been pretty much taken care of, but that can be changed at any SLIB meeting, you know. So that's something that for myself, I'm interested in making sure that gets memorialized in statute. I'll give you the nightmare income problem that we have. There's a company out there that is one of the largest, if not the largest, company that generates electricity from hydrocarbon sources, natural gas and coal. And of course, when the Biden administration came in, they pivoted because they figured that all of this stuff was gonna start to go green, and they wanted more capital. So they have a website that's primarily focused in gaining European capital. And you know how the Europeans are, they're probably greener than San Francisco. So it's and the statements that they had on there was, I guess I would recognize them as egregious. And one was that they were, I think, a champion in it wasn't carbon capture, it was just basically to get rid of carbon. And that to us just said, well, you know, being from Wyoming, that means you want to get rid of our coal industry, oil and gas industry. Yet the dichotomy is that we had a opportunity to invest in a coal-fired plant in Ohio. It didn't burn Wyoming coal, but it's a coal-fired plant. And because of the situation at that time, this last summer, we could buy it for 10 cents on the dollar. And so $100 million was going to return us $50 million a year for at least the next 5 years, even if Biden was in the office, and longer, of course, if Trump gets in there. So, you know, that $100 million, we lost $250 million of potential revenue. And it really didn't even get to a vote. Our CIO looked at that and says, well, why don't I poll the IFC members, or not the IFC members, the SLIB members, and see what they think. And the vote didn't even get to me or Chuck with that, you know, that it was pretty much stopped before it even started. And that was because they had something there. Now, there's something that's called I guess it's a separately managed asset. And what we do is contractually with every one of our companies, we do side letters. And so if there's something that's not quite right, we make them agree to everything in our ESG policy, that anything that they do in managing of our money is going to be under our standards. And so it's separately and apart in a silo, apart from anything else that they do in their company. And it's interesting that when you write a ticket for $500 million, what people will do, you know. And so KKR backed up, you know, all the way to go with us on that deal there. And this company was going to do the exact same thing. They said, you write it, Kurt, anything it is, you put it in there, you put it in the contract, we'll adhere to it, and you put the language in. And that, I guess there is a clause, I think, in this particular language that if there's no viable opportunity to do something else. And that's something that, probably would like to have some discussions on. And the other interesting thing that Texas has one of the most stringent ESG policies on statute. One of their investment folks were able to take a $300 million sleeve. And so it was, problematic that my policy that we put in, which is probably not as strong as what this one is, that it caused us to walk away from that potential. Now, this particular company, they recently sold $18 billion worth of assets in California. I think it's Calpine Gas or something. And I saw their, the projects that they're teeing up over the next, less than a decade, and 3 of them are in Wyoming. And at this point in time, I can't invest in those projects. It's confidential, I can't tell you what they are, but there are things that are a lot of other people's neighborhood and backyard. And so we got to figure out some way, I would say, is when it directly affects us, affects our natural resource industries, that there's a way that we can invest in these as long as we contractually make these people agree that they're going to operate by all of our standards in that area. The reason that came available because the Europeans didn't want to invest in a coal-fired plant, and so they're looking at other people, and what their main goal is, I think, is to get a group of states like us, Alaska, North Dakota, Texas, Florida's along the same lines, even though they're not an energy state, and be able to go out and buy these assets at a relatively, it's not going to be as cheap as it has been the last few years. But that's something that we need to contemplate going forward here. That there's a saying that my father and grandfather always told me, he says, don't ever get mad at your money. And essentially that's being a fiduciary. And if you look at what we do here is that we're basically a fiduciary. Our goals, and stated in statute in the ESG policies, the first thing and foremost is to the benefactors of each one of these funds. And I broaden this out a little bit to include the citizens of Wyoming as benefactors, to get to the point that these are areas that we have to consider what we do as a whole to the state. Now, that's not being a true fiduciary, that's being a part of a stakeholder fiduciary, which is a problem of where we're going down these lines. We're turning everybody into stakeholder beneficiaries and forgetting, especially like in the retirement system, you don't want to make them feel good, or you want to give them enough money so they can make their house payment. We're entitled. I think they need to make their house payment, need to put food on the table for their family. And so that's, I think, pretty cut and dry on that one there. That's a higher level than maybe putting money into the general fund, but it's used for the same type of purposes. The work that you guys do is really important. Education, that's really important. Hathaway Scholarship, that's really important. All the things that are in our statutory and constitutional trusts, the goals that are stated in there are stated in there for a purpose. And so we can't lose track of what our purposes are, and that's being a fiduciary. Now, on the other thing, I think it's pretty simple. There's a lot of verbiage in there in all these bills, but I think we stated fairly straightforward, is that there's a difference between pecuniary and non-pecuniary. Now, when I first heard that word, I had to look it up, and so it basically, pecuniary means having to do with money. Non-pecuniary, is everything else. It's not dealing with money. And therein lies the line. And that's where we look at it, is that and it's a weight a lot of this stuff that's in these statements, you know, I think Peabody Coal and Arch Coal, one of the two largest coal companies in our universe, they both have very, you know, direct ESG statements. And so, you know, cannot be prohibited of, dealing with that. You look at greenhouse gases and you look at what we've done in Wyoming. In the 90s, we made provisions to be able to capture carbon with agricultural products to actually, and there was a carbon market in London that didn't last long. That's why this thing was spun up. But we would have been able to return money back to our ranchers and farmers, you know, for them actually being in the greenhouse gas capturing business, because they are. In fact, I was at a conference up in Alaska of sovereign wealth funds, and had a presentation by an individual that said that, if everybody just used no-till farming, and you got about a 7-year compost factor in the soil, that you could take care of all your problems with greenhouse emissions. And we did that in the 90s. But you know, people aren't doing the easy thing. They try to figure out the most expensive way, you know, to create a new industry and to create new technology to do something that nature does by itself, photosynthesis. And it's frustrating. But I'm kind of getting it a little bit in a circle here. So why don't we look at what we're doing already? And I don't know what the easiest way to do this, but read it. I mean, it's been on our website for well over a year. But what we say is, accordingly, all individuals shall act in the best financial interest of beneficiaries while evaluating managers, vendors, asset allocations, investment potential in order to obtain the highest total return on a risk-adjusted basis while adhering to all applicable rules of law. Fiduciary decisions can only be based on pecuniary factors, meaning they have been prudently determined and expected to have a positive effect on the risk-adjusted return of investments based on appropriate investment horizons consistent with the fund's objectives and investment policies while adhering to compliance, statutory, and regulatory guidance. And this is where I get a little bit in, I would call, the findings area. Pecuniary factors do not include the furtherance to environmental, social, government's political, or ideological interests. Now, you know, that knife cuts on both sides. And so think about that if you're going to be true to, being a fiduciary and true to not letting non-pecuniary factors sway what's going on, that does not include environmental, social, governance, political, or ideological interests. And then I say these ideological investment criteria, which have crippled, corrupted, disadvantaged, subverted, damaged, or otherwise harmed the children, citizens, industry, and financial well-being of Wyoming and America, we expect they will continue to do so. We put a finding in there, that's my own opinion. Say non-pecuniary factors do not provide confidence in increased returns or lower risk. Conversely, they may be cause for alarm and concern. Non-pecuniary diversions from fiduciary responsibilities will most likely result in lower returns and increased risk, resulting in less funding being available to the state of Wyoming in returns and increased risk in general. In addition, all vendors must adhere to the laws of Wyoming and the United States. Every one of our contracts that we implement, they have to adhere to Section 3.5. They have to sign on it that they're going to do it. And we will be getting the attestation and the reaffirming of that this spring. And so that compliance part is being implemented this spring. And so it's nice to be able to write those tickets and people will come here. Now, that being said, our $30 billion is just a speck when you're looking at the economy of this country and the world. You know, but we have been out there in these areas in private equity and private credit, and we've been looking for, you know, the top tier investors. And I would say that, you know, the jumping off point that you guys really ought to seriously consider is substituting this particular piece of legislation for what came out of the Senate 2 years ago. That one got stopped before there's full debate in the House. And it was one of those sessions, I would say, is that had it gone forward, it probably would have killed 150 House bills because people just love talking about ESG, you know. But if you can keep this thing simple, because it's black and white, you're either making money or you're not making money. You either have companies whose main thrust is non-pecuniary, or you actually have companies that want to have it. To Representative Reagan's point about the mutual funds, the way this and other things, if this bill was enacted during the Biden administration, it's broad enough that we could not have even invested in U.S. Treasuries, because the administration was essentially without law implementing these social things. And so they were basically without law, without authority, they were doing something that they shouldn't have been doing. And that it's broad enough right now in this draft, we couldn't do U.S. Treasuries. And the S&P 500, I think it's 494 of them have social deals. So there's only 5 stocks that we could do. And if we didn't have some wiggle room with our custodial bank, and they said that we couldn't deal with the bank to custody our money, there were only 3 banks available at that time. 2 of them were in China and 1 was in Japan. I would have had to offshore, you know, essentially, if I adhered to the strict language of the law, which is so broad, it's mind-boggling. And you know, to the discussion that you had about, well, what's the standard for us to determine whether or not we're violating this? Well, we would have to hire a mail clipping firm and somebody to monitor every podcast, every conversation, every newspaper article of every one of the major people's officers. And so that's what's in the law, regardless of how it might be operated. And so I would say be really careful about what you write because of the unintended consequences. You know, I think we all want to do what's right for Wyoming. We want to make sure that we can stabilize our coal industry and our energy industry. And I think that the biggest thing that we want to do is we want to tell everybody in America about how much this impact has been. If you want to know the impact, take that report that we had a little, I guess I call them dog and pony shows or whatever here the other day. We had 12 people, you know, show up. All the legislators were invited, but it's on your website. And both the LSO and Rod Gobby at the university has gone through, quantified a lot of that, and that's in that report. Essentially, you can look back even before the Paris Accords. There's a little star on this chart about how the coal is going down in production. That's the Paris Accords. And essentially, this started long before. The decline in our production started long before the Paris Accords. But you can remember when Al Gore was pushing this stuff, and this whole thing just started going down. At that time, we started losing market share in the energy industry. But essentially, it's about $150 million a year in coal lease bonuses because they shut that off a few years ago. And that's what we built our schools with. As a We don't have that revenue stream to build schools. And it's about $500-600 million a year in actually what we're getting in on coal. So, $600-700 million is what we've lost just in coal. In the meantime, China, since the Accords, has built twice as many coal plants that we have in our country or more. They build a new 550 megawatt plant every month. And if you're going to say what's going to happen to AI, it's all about energy. And that's where our really, I think our big shot in this state is to make sure that we have access to capital within here and the partnerships that I talked about. So we can start building generation plants, next stage generation plants in Wyoming. And we can put data centers right next to them. And so there's huge opportunities for us. But we want to make sure that we don't get mad at our money, because if we get so far over our skis on trying to protect, the world's society and not looking in our back doors what we got to do, we're going to miss this shot. But we got to be cognizant of it, because like in this one case, we know we've got enough money. We know these guys want us in their collective so they can actually do some of these projects. I'm going to go back to them. I'm going to go to that webpage, and when you say decarbonization, why don't you say what you're really doing? And if it's carbon sequestration, that's easier, I think, for us to understand than saying that they're going to decarbonize. So, your easy thing is to go back to where we had, I think, some fairly good consensus coming out of the Senate. And what the big thing that they did in that one there is they took away this deal about every one of us in our office and every one of our managers getting penalized for some very, very subjective standards. And frankly, we're going to try to hire a new CIO. This bill is in there. You can probably, and I'm not being, I think overreactive, that you can probably say that better half of my staff or all of them are going to walk out the door. That every one of our managers are going to say there's a material change in our contracts, and they're going to walk out the door. And we're going to be left with nobody to invest and no markets to invest in. Now the Senate looked at that and understood that, and that's a reality. It's no hyperbole. And so they understood it, and they got rid of the most troubling parts of what this bill has. And that's a good place, I think, for you guys to look and start, get a copy of that from LSO, look at it, make it a substitute bill, and then jump off of that. We got our proxies already locked and loaded. They're in good shape. The cost is about $75,000 a year. I think basically WRS doesn't do that. I think would probably, they'll let you know, but I think it would probably cost maybe $150,000-200,000 for them, because they've got bigger stock.
Thank you.
Yep. Let's see, I'll tell you how we handle each one of these things when we
Okay.
find a problem. That's the second one there.
Mr. Treasurer, we have a lot of testimony to cover, so
Right.
please proceed.
Okay, all right. It says the state treasurer's office shall respond to an investment partner when it discovered that they act in a non-pecuniary manner and the state treasurer's office identifies a potential detrimental outcome to the highest total return on a risk-adjusted basis or a loss to the state's revenue in general. By communicating these concerns to the management, its board, or other responsible individuals, and taking one or more of the following actions to ensure that all fiduciary decisions are made by investment partners based on pecuniary factors, which may include but are not limited to requesting to change the policies, voting proxies to force change, and divestment and/or replacement with competitive alternatively. Ultimately, all partners must adhere to the standard of care of being a fiduciary in accordance with the policies outlined in the investment policy. Everybody signs off to that. And so for all the people that we've onboarded, we haven't had any particular particular problems. There was one, I think, circumstance where we had onboarded a defense contractor. And the defense contractor had state-of-the-art contracts in, I think it's the F-35, the B-1 bomber, the attack submarines, half dozen other different places where they've got different kind of technology that's irreplaceable, that's right in there. And they have top clearance access to the Pentagon and everything else. They're kind of first in class. But they did have something in there that was an ESG policy. But I think to my thought is that, you know, we got the largest missile base, or one of the largest business bases here. It's a national defense thing, and so it didn't come to, I think, a level that said that let's walk away from this deal. So,
All right, thank you, Mr. Treasurer. We have some questions for you.
yeah.
Representative Lawley.
Right.
Thank you, Mr. Chairman. Thank you for being here, Treasurer Meyer. And I want to applaud your work that you did in August of 2023 when we failed to act on this issue, and the work of the SLIP board and some of the things you've gone over today. I think you've made some great progress, and I appreciate it that you've done it. My question is, what I think I'm hearing from you is that this bill as it's currently written would create issues for you as you try to execute the policies that you have in place now. Is that correct?
Mr. Treasurer.
That's correct. A lot of it is the subjectivity, and, you know, we're looking at it is that we do great due diligence and deep dives into every one of these companies. So we know what's on their websites, and we know what businesses that they've invested in. And we pulled away from one company that's a private equity company. They had an investment in a company that wasn't doing very well, and exactly, it's essentially they were investing in drag queen costumes, and you know, it was not doing very well. It was a decision that definitely was an ESG decision for the company, and they were losing money, and they made that decision, and they're going to continue to lose money on this. And so even though that they were knocking it out of the park on all the other things, we felt that the management was so committed that they would make poor financial decisions to us in the future. So, yeah.
All right, thank you. Follow up?
Thank you, Mr. Chairman. One other question. You mentioned these separately managed asset agreements.
Yes.
About how many of those do you currently have?
Mr. Treasurer?
You know, I would say from the extent that we have separately managed contracts and side letters, everything that we've done in the last year, you know, bears that. But whether they're actually organized as that, you know, they're contracted as that, but
see.
not necessarily organized in that one specific structure.
Okay, thank you for your testimony. Let's move along to some other elected officials now. Anybody else in the audience, elected official, that would like to testify? Okay. Any other departments of the state that would like to testify? First one up here wins. Please state your name for the record.
Mr. Chairman, members of the committee, my name is David Swindell. I'm the Executive Director of your Wyoming Retirement System. Joining me here at the table is our Chief Investment Officer, Sam Masudi, and I believe we have our Vice Chairman of the Retirement Board, Eric Nelson, on the Zoom. Chairman of the board, Tom Chapman's not able to join us this morning. He had some personal issues. He's presently on an airplane flying back to New York, so he apologizes. I believe he did send some emails to members of the committee on this topic. Appreciate being here. We appreciate the kind words about the retirement system that were mentioned earlier. I think this isn't the normal committee that we testify to. We know Representative Knapp from CATFin. But I think this committee is just reasonably familiar that we are the retirement system. We have 36,000 pensioners. We paid $800 million in benefits last year, most of which stayed in Wyoming, 79%. So that's like $650 million goes to your constituents. So I think everybody knows that. What you may not know is kind of how this is financed. We get contributions in from employers and employees, but a pension's only paid for, that only pays for about a third of the cost of the pension. 2/3 of the cost of the pension is paid with investment earnings. And that means we run an investment corpus of about $11.5 billion presently. And that's separate and in addition to the $30 billion that the treasurer mentioned. We've been very successful in doing that. Existing language in the state constitution, existing state statutes, all say that we invest solely for the financial benefit of the members, and that we're not allowed to consider anything else other than that. These statutes and the constitutions is long-standing language, and we have never invested in an ESG fashion. We're ESG agnostic, strictly for the financial benefit of our members. I also think that the committee is broadly aware, as the bill sponsor mentioned, we've been very successful. In the, as of 30 June, the 5-year trailing returns, we averaged 9.84%. That ranked in the second percentile of 100 pure funds tracked by our investment consultant with public funds with $1 billion or more under management. I mean, we were the second, the only trouble, it's not going to get any better than that. We beat the median fund by more than 200 basis points. The leverage is quite large. 200 basis points on a $10 billion, $11 billion fund, you're talking $200 million a year difference. And that compounds. So it's an important thing to understand that if you start to degrade your investment performance, compounding works the other way, right? So you start to lose money from what you potentially could have earned. So with that, the issue here is not in the purpose of the bill. We don't invest in ESG. We're not allowed to. We never have. We never will. It's because of the statutes and because of the policies of the board and the staff. We're here for the benefit of our members solely, not trying to advance any social causes. So we can applaud the purpose of the bill. And the treasurer has taken a lead in the proxy voting issue. And maybe we need to follow that. We've investigated that. Just probably need some administrative resources in our budget to get it done as soon as you would like. The issue with the bill is simply in the details and the ambiguity in some of the standards. There were some really good questions here from the committee that I heard. Chairman, you have a really good committee here. That's the issue. There are passages in the thing that expose managers to potential risks that they don't see with other clients. I mean, what does it mean that a manager would be accused of violating his fiduciary duties, subject to 3 times fee penalties, if they reduced a position in a firearms company? Well, maybe the stock had a good run. It's time to take profits. Maybe they just had a better idea in another sector. Now, maybe it was for some social motive, but the sell ticket doesn't tell you that. And the act and the details and language say if you reduce your position, that's evidence that you violated your fiduciary duties. And so no manager is going to sign up for that kind of risk. Even if we could persuade a manager to do it, they'll take to their legal department and they're going to say there's risks here that we don't see with other clients. And no one needs our money that bad. As the treasurer mentioned, although it's $30 billion for the treasurer, $11 billion for us, those are small numbers in the financial universe. We don't have that kind of leverage, particularly with the best managers. I mean, there's always somebody that will take our money, but not the best managers. Sam works hard to try to negotiate the best deals and get in on the best managers, and that's why our performance has been so good. But this would really handicap us. We don't think we could successfully negotiate an investment management agreement with any manager under the terms of this law. Now, there is an out clause. It says you only have to enforce the manager to sign up for this and expose the 3 times penalties unless there's no financial alternative. Well, the problem with that is that who gets to decide that? It's not clear in the bill. What evidence is necessary and how often do we need to prove it? Who do we need to prove it to? It's obviously going to be the source of challenge and litigation, which in itself is costly and energy draining. And in the end, any agreement, we could say that, no, it's not about the health insurance that the company offers on abortion or things like that, or that you're allowed to adopt new technology and reduce your greenhouse emissions if you think that's most profitable for your company. But that's not what the bill language detail says. And in any agreement, it takes two parties, right? And so the other party would have to agree with that, and they will not. Their lawyers will say, there's risks here that I don't have with other clients. We just need to walk away. And that's why this thing causes us so much problems. It would severely impair our investment operations. We would not be able to enter any new agreements. I'm not sure we'd be able to hold on to some of our old agreements. For example, one of the things that Sam's team does is we negotiate favored nation status. If we negotiate with an investment manager to manage, say, $100 million or $200 million of our money in a particular strategy, there's a fee schedule, and we agree to that. But if they offer a better deal to some subsequent investor, they got to give us the same deal. Well, maybe that happens. So there's an amendment to the contract. So our original contract may have been dated prior to 1 July 2025, but now there's this addendum. Now I've got a signature on a contract that's after that date. Does that expose the manager to the terms of this? Their lawyers are going to say, this is a problem. We may not think it's a problem, but they will, and that's the issue. That's why we suggest that some of these problematic areas be modified or deleted from the bill. And then you could have a bill that would express one more time in maybe new ESG language, because admittedly the existing language in the Constitution and the statutes don't talk specifically about ESG. This is kind of a new fad. And this stuff goes back decades in some cases, the existing statutes. And maybe we can make some improvements in proxy voting. As I said, the treasurer has taken the lead on that. We could, make sure the committee understands what we're talking about. We did a recent snapshot. We believe we were invested in mid-December in 5,671 separate companies across the globe. So every one of those companies has an annual shareholder meeting, and there might be 10 or 11 proposals at that shareholder meeting to elect directors, to approve the audit firm, to approve the compensation plan for senior management or whatever. And yeah, there could be some environmental initiatives. It's happened to some companies. But to track that many companies, that many meetings, it's a big job, and we don't have the people, the resources, the tools to do that. Now, as the treasurer mentioned, this can be done. We can hire a firm to do that. And they can vote, instead of having our managers vote our shares, what we do now is we tell our managers to vote our shares in the best financial interest of the fund. But admittedly, there is no report on our website that lists how all that went down. We can find out how it went down in any specific case, but it's not the clarity and transparency that's required in the bill. And maybe we need to do that. Our issue is I just need an appropriation to do that out of our administrative budget. We've had some preliminary conversations with a couple of vendors that would do it. It's going to cost between $150,000 and $250,000 a year for the size and complexity of our portfolio. And I just don't have that kind of flexibility in the professional services budget for the investment team. I have a little bit of dry gunpowder, but nowhere near that. So it'd be helpful to have an appropriation. Otherwise, we would do it, but we would delay it until the next budget when we could get an exception request through Appropriations Committee. So anyway, those are the issues. Sam, do you want to bail me out a little bit, and any comments you need to make? Oh, okay. Sam reminds me that I have the vice chairman of the board that's online, and I probably ought to defer to him. Unless there's questions for me, I'd like to have Mr. Nelson
Let's take some
testify.
questions for the director. Any questions for the director first before we go online? Seeing none, let's, Mark, can we bring in Eric? I don't remember the word.
Yes.
Thank you, Mr. Chairman. Can you hear me?
Yes, sir.
Again, my name is Eric Nelson. I have been a trustee of the retirement system since 2015 and currently serve as the vice chair and investment committee chairman. I certainly appreciate the opportunity to appear remotely before you, especially as I look out my window and see the snow coming down here in Casper, to give some testimony regarding House Bill 80, Stop ESG. I think Director Swindell really summed up some of the concerns very nicely, and really chronicled some of the successes we've had in the last decade that I've been a trustee, including our excellent returns in not to forget and emphasize the fact that we have been wildly successful in building a great investment team, and we've had stability, and they've done a great job. From the board level, it can't be stated enough. We have never, will never utilize ESG principles when making investment decisions. As fiduciaries, as trustees, we are obligated by law, the Wyoming Constitution, Wyoming state statute, to seek the highest risk-adjusted returns for the benefit of our participants. And so philosophically, the board is aligned with the objectives of this bill, and that is to clearly state that ESG will not be taken into consideration, nor will any other, as the treasurer mentioned, non-pecuniary issues be considered. We're looking purely at the financial best interests of our participants and the citizens of Wyoming. But as Director Swindell pointed out, the current wording of this bill gives the trustees as well as the staff great pause. While we state that here is our ultimate objective, the plain language of the bill, I think, could result in what I would characterize as catastrophic unintended consequences. During my day job, I'm an attorney, and so I try not to play an attorney on this board. But our intent can be one thing, but once that law is enacted and those words are on paper, they have their own life. And if they're going to be construed and applied by courts of law, interpreted by legal departments across the world based on what is on the paper. And so we feel that that'll have a chilling effect, will inhibit our ability to invest. And perhaps just as worrisome, inhibit our ability to retain and recruit investment talent, which will potentially result in hundreds of millions of dollars in lost revenue for our participants in the retirement system. We feel that these portions of the bill as currently drafted that we have so much concern with are unnecessary. Many of these parts can be stripped out, can be amended, and we feel confident that a bill can be brought forward that would, in fact, obtain the results that the sponsors of this bill are looking for, while not inhibiting and not having those unintended consequences on our investment and our investment teams. And I know that WRS, the trustees, and the staff remain available, ready, willing, and able to provide information and assistance in making those changes. So Just very briefly on proxies, I think that the board is certainly amenable to addressing that. And as Director Swindell indicated, the treasurer has taken the lead on that. What is prohibited or inhibited WRS from doing that at this point is the lack of administrative resources. So provided we have that ability and it is the desire of the legislature, we certainly would address that. So in conclusion, I just want to once again emphasize that ESG is not part of our calculus when making investment decisions. It never has been and it never will be. And we're committed to working with the legislature going forward to craft an appropriate bill. We've enjoyed a really strong relationship, I believe, with the legislature, working together for the best interests of the citizens of Wyoming and the participants in the retirement system. And I certainly look forward to continuing that relationship. So on behalf of the citizens of Wyoming, one of 6 who are participants in the retirement system, we thank you for all of your hard work, dedication, and support. And with that, Mr. Chairman, I would certainly stand for any questions.
All right. Thank you, Mr. Nilsson. Any questions for Mr. Nilsson? Seeing none, thank you very much, Director Swindell.
you.
Any other state departments that would like to testify? Okay, any citizens? Director, you have anything else you want to say? We're running out of
Do you have any
time.
questions from our Chief Investment Officer?
No, I've already asked that. Okay. All right, any citizens that are here in the room that would like to provide testimony? Mr. Winnie, would you state your name for the record, please?
Yes, sir, Mr. Chairman. Bill Winnie, Sublette County. All I can say after listening to the treasurer and the other gentleman that just spoke is, wow, the devil is in the details. But I would like you to keep in mind what your goal is, which is to make sure the next guy in Treasurer Myers' shoes is just as dedicated as he is to making sure that we invest money properly. ESG is a way to the pot of gold at the end of the rainbow. Margaret Thatcher once remarked, I'm told, the problem with socialism is they eventually run out of other people's money. ESG is a way of getting control of that money so they get a bigger pot of gold. Without a tax, without having to go through legislation and things like that. So, you know, what you want to do here, what Representative Knapp wants to do is the right thing. But as I said at the beginning, the devil is in the details, and I wish you luck on this one. I would offer a side note. When you talk about industries and some of their things like reducing emissions and things, I'm well familiar from my background with what it costs to attain a zero leakage boundary in piping. And I would note that for those companies involved in transporting natural gas via hundreds of miles of piping, that going about the business of getting a zero leakage boundary may be good environmental business, but it is also smart business because you get more product at the other end. So there's some things in there to weigh. Subject to your questions, thank you.
Thank you, Mr. Winnie. Any questions for Mr. Winnie from Sublette County? Seeing none, thank you very much. Any other citizens here in the room that would like to testify? Are you testifying as a citizen or as a representative from an organization? Okay, we're still open for any citizens that would like to testify that are here. Seeing none, we'll go on to representatives from organizations. Thank you.
Thank you, Representative Heiner. My name is Ron Sniffen, and I represent the Wyoming Coalition for a Healthy Retirement. Coalition members include the Wyoming Public Employees Association, Federal Firefighters of Wyoming, the Wyoming Education Association. We have some law enforcement groups that are with us as well, and other education organizations. Together, we work to protect the retirement system and the participants who benefit from it. We are concerned about the impact of House Bill 80 and in its current form on the Wyoming retirement system. The Wyoming retirement system estimated in their fiscal note that this legislation could reduce revenue for the state's pension by nearly $1.2 billion over the next 3 years. It is not in the best interest of the state, its retirees, or its taxpayers to forego free market principles by limiting competition. Wyoming has always been business-friendly and a strong supporter of the free market. House Bill 80 would break that tradition. I appreciated Treasurer Myers' statement earlier today. Do we want investments to make a house payment, or do we want to make a political statement? I would add that for our retirees who haven't had a COLA since 2008, the question could be, do we want our retirees to have a hot meal, or do we want to make a political statement? Please vote no on this bill in its current form, or at least amend it so that it does not tie the hands of the investment officers. And with that, I'll take any questions.
Thank you, Mr. Sniffen. Any questions for Mr. Sniffen? Thank you.
Thank you.
Other agencies or other representatives from agencies? Representatives from private or from businesses, I'm sorry.
Thank you, Mr. Chairman.
Please state your name for the record.
My name is Kevin Reddy, and I am the president of the Federated Firefighters of Wyoming. I've been a firefighter here with the Cheyenne Firefighters for 23 years. And we proudly represent all the career firefighters in the state. And our members and our retired members fall under the Plan B pension in the Fireman Pension Fund. We rise in opposition also to House Bill 80. And there's been a lot of great testimony on the dangers to the potential of losing investment prospects. I'd like to remind the committee that when we look at the loss of nearly $1 billion over the next 3 years, that comes out of our members' pockets, out of our employers' pockets. When our funds aren't 100% funded, the legislature comes to the employees and the employers and asks for money. When we adopt some of these ESG principles or anti-ESG principles, we lose out on those investment returns. It's not the oil companies or the environmental companies that are going to make the funds whole. It's the employees, it's the firefighters, and then the retirees have to forego any post-retirement benefits based on investment profits. So with that, we'd ask you to vote down this bill or amend it to the point where our investments meet the best option for our retirees and for our members.
Thank you, Mr. Reddy. Appreciate you being here, and for those that you represent, we applaud them. Any questions for Mr. Reddy? Thank you. Any other organizations? Mr. Moline, would you kindly state your name for the record?
Yes, Mr. Chairman, Brett, excuse me, Brett Moline, Wyoming Farm Bureau Federation. This is a tough situation that you folks are in, and I understand it. I find it, I would like to see this concept at least go forward. I mean, trying to figure out how to say this politically correctly. I find it a little surprising that the best investments are potentially investments in businesses that are against the industries that make Wyoming. And I understand the quandary, and I wished I knew how to fix it. So I would like to see this concept go forward, that we would at least target businesses. I understand we have to make a good rate of return. That's the job, but at least have this concept go forward where we can at least maybe target businesses that aren't against us. I don't know if that makes any sense, but and in agriculture, we're very dependent upon the mining industries, oil, gas, coal. We need those to be a viable entity to keep my farmers and ranchers producing. I wish I was coming with more answers for you, but I understand the quandary, but I'd like to see this concept go forward, or at least for some more discussion. With that, Mr. Chairman, I'd take any questions you or the committee may have.
All right, any questions for Mr. Moline? Seeing none, thank you. We'll get to those on Zoom here shortly. Representative, what I do is those that are in attendance first, and then we go to Zoom. Please state your name.
Mr. Chairman, my name is Lanny Applegate. I serve as the vice chairman of the Volunteer Fireman's Pension, and all of our investments are passed on to the big board, as you've heard from those folks, to do our investments for us. I hear a lot of good comments from you folks, a great lot of comments from the treasurer and Director Swindell and the vice chairman of the big board. And I think this bill has some merit, but I think there's enough questions about it and whatnot that I think at least, bare minimum, I would suggest that maybe do an interim study and bring the treasurer and director of Wyoming Retirement and his board to come in and visit with this and make this a better bill, a stronger bill. And I think that potential is there. So with that, I would stand with any questions.
Thank you, Mr. Applegate. Any questions for Mr. Applegate? Seeing none, thank you. Thank you. Any other individuals representing organizations here? Mr. Obermuller? Please proceed.
Thank you, Mr. Chairman. Members of the committee, pleasure to be here. Nice to see you all. Mr. Chairman, my name is Pete Obermuller. I'm the president of the Petroleum Association of Wyoming. With me here, just so that you could meet him and put a face to the name, is PAW's Vice President and Communications Director, Ryan McConaughey, who will be here this session more than ever before. So I wanted this committee in particular just to see him as he'll be working with you all too. Mr. Chairman, with your indulgence, just very briefly, I've met most of the new members of the committee. This committee obviously has most of the jurisdiction over the activities of oil and gas production in Wyoming. And so with that in mind, just very quickly, the Petroleum Association represents all facets of the oil and gas industry, from the exploration side, which interestingly in Wyoming still exists. We're still trying to find resources in Wyoming, and we don't know the bounds of our resources. So there's an actual exploration component in Wyoming, which is in some ways unique to our state. Then we also, of course, represent the folks who, once it has been found, bring it up out of the ground, and the people who transport it across the state and the nation to get the product to the places that need it, which is everywhere. And then downstream refiners, and then everyone who orbits the oil and gas space that helps make it all happen. Environmental consultants, geologists, petroleum engineers, oil and gas attorneys, et cetera, are all part of the Petroleum Association of Wyoming. Thank you, Mr. Chairman, for letting me do that introduction. I'll do that once and won't do that again until 2 years from now in the 69th legislature. So regarding this bill, Mr. Chairman, PAW does not have a position on this bill. And in part because we're aware that there may be other ESG-related legislation coming to the fore, and we'd like to see what the universe is before we make a full-on decision. But I did want to mention a couple of things and offer a couple of specific suggestions on this bill. First of all, 2 years ago when this bill was brought, I and we at PAW had a little bit of difficulty cutting through the noise to talk about what we thought the real problem was related to ESG and ESG investing. And that real problem in our mind was that at that time, there was a larger amount of Wyoming's Permanent Mineral Trust Fund than I would have guessed. I don't remember the exact number now, but it was somewhere in the order of 7 billion or so of our total fund were being managed by managers who had signed pledges to actively work towards specific targets of greenhouse gas reduction by specific dates. So reduce it by X amount by 2030. Unrealistic expectations that industry couldn't meet, and that is, in fact, in our opinion, harmful to industry and harmful to the state. So what we saw was that, particularly in the Permanent Mineral Trust Fund, this is not quite true for the retirement funds, but in the Permanent Mineral Trust Fund, money that oil and gas and other minerals put into the fund were being used by managers. Our money was being used to back activist shareholder votes and other actions against us, in our opinion. That was the crux of the issue. Now, Representative Knapp And the Capital Finance Committee took that very seriously and testified in front of that committee. I think Representative Knapp probably remembers where we talked about that specific issue. And that committee took that seriously. And they worked with the Treasurer's Office to start working on this proxy voting issue, to get a better handle on how our money was being used in terms of proxy voting from our money managers. Representative Knapp in particular, that committee and the Treasurer took that seriously and have made great strides in solving that issue. And it is work to make sure that we have a handle on that. And I think we've come a long way. So that part I think is great, and the bill that deals with proxy voting, the parts of the bill that deal with proxy voting, very, very helpful. So wanted to provide that background about kind of where we were, about what we saw as the issue. Related to the bill itself, Mr. Chairman, as you know, of course, as has been talked about, the bill is intended to guide how we use our money and what Wyoming's money can be invested in. And it's a little bit, because of the way it's written, it's a little bit difficult to follow sort of the double negatives that are in there about what a financial decision is. But I want to direct your attention, and you brought it up, Mr. Chairman, and Representative Larson brought it up on page 3, lines 13 and 14. So what the bill, that's the eliminating, reducing, offsetting, or disclosing greenhouse gas emissions. What the bill does is what the bill does not do is it's not saying that any of my companies or anybody else, my member companies, can't take, work on doing that, because they are, as you've discussed. And in some cases, in a lot of cases, they're doing it beyond what law requires. They're doing it in order to differentiate themselves from their competitors in other states, particularly our natural gas producers who sell natural gas to places on the West Coast who know they need our natural gas but don't love it. And so they're looking for ways to, they're looking for differentiated gas that they can purchase in contrast from other places. So they take those actions. The bill doesn't prohibit them from doing that. What I fear is what the bill says is Wyoming couldn't use its oil and gas invested money to invest in a company that is doing those things. And I think, Mr. Chairman, that it could be solved, and I would just suggest one word amendment on line 13, and then some formatting that simply inserts in front of eliminating involuntary, and then be involuntary elimination, reduction, offset, or disclosure of greenhouse gas emissions. Because if I'm, and Representative Knapp, I'd ask you to correct me if I'm wrong. My reading of the bill and what you're trying to accomplish here as the bringer is you're trying to prevent coercive action, not voluntary action. So that would be my one suggestion. The only other one is policy decision. I understand the chairman's point that you may view this bill as investment policy as opposed to energy policy. My personal opinion is I like to keep energy policy, and would prefer to remove subsections D and E, starting on page 4, lines 4 through 14. Now that's not, let me be clear, that's not a value judgment. I think the legislature and the committee and anyone who wants to deal with ESG policy related to those things in D and E, that is certainly within your purview and it probably should be followed. My personal opinion is I would like to keep energy policy. And I will leave it at that, Mr. Chairman. Happy to take questions.
Thank you, Mr. Obermueller, for your input. Appreciate that. Any questions? Seeing none, thank you.
Thank you, Mr. Chairman.
Any other representatives of industry or business that would like to speak? Mr. Daytai, recognize that we are running out of time and we've been on this bill for 2 hours now.
And Mr. Chairman, recognizing that you've been on the bill for 2 hours, I will make it 2 hours and 5 seconds. Travis Detail with the Mining Association. I would echo everything that my colleague with the Petroleum Association just said. And with that, I would stand for questions.
Thank you. All right, thank you. Now we'll go online. Mark, who do we have online? Any hands lifted?
Patrick Fleming.
All right, Mr. Fleming works for our treasurer's office. Mr. Fleming.
Yes, thank you. Thank you, Mr. Chairman, members of the committee. Patrick Fleming, CIO for the Treasurer's Office. I would just like to put a little more fine tuning points on what the treasurer has already commented on, and also comment on how our managers view this bill. And they've had very high-priced lawyers look at how they determine the verbiage on this. So just a couple clarifying comments. First of all, talking about quote unquote reducing greenhouse gas emissions. Mr. Chairman, you're absolutely correct. There are many companies out there in Wyoming and elsewhere that have these statements. As the treasurer mentioned, just to clarify, 494 of the S&P 500 companies have ESG comments or statements. That would completely eliminate us from being able to invest in these companies. Your comment about companies in Wyoming, this is from Peabody Energy's letterhead or web page. Any of you can read it. But Peabody Energy, as you know, is one of the largest coal producing companies and number one in Wyoming. But quote unquote, Peabody has responsible to reduce our greenhouse gas emissions and move to zero emissions by 2050. That is, it's in their letterhead stated. This is true for many, many companies. I understand that you could say whether or not you're voluntary limiting or what have you. There's certain states that have flaring guidelines. So yes, they are forced to reduce greenhouse gas emissions. It's just problematic across many different areas about this statement. We also invest in many companies that take advantage of flaring, take advantage of methane emissions and control that and make money off of it. We're investing in a company now that does that. So would this eliminate that type of investing because their job is to reduce greenhouse gas emissions for the benefit of the state of Wyoming and us? So it's really difficult. The devil is in the detail, as one of your someone testified before, is very problematic. Big picture wise, someone commented about when the treasurer's gone. It's not only the treasurer, it permeates through the entire organization. It starts with me. If there is any firm out there that is trying to invest for non-pecuniary reasons, they don't even make it past the first comments of what we're talking to. We will not invest with someone who is doing this. It's just, it doesn't happen. Then it goes to the treasurer. The State Loan Investment Board has in our IPS statements that make our managers adhere to this, so they cannot do this in any factor. The next one would be on abortions. There's many states that allow abortions, so if 10% of the S&P is in healthcare, we would not be able to invest in companies that are just abiding by state laws. Another one is ammunitions. There's a thing called the Cluster Munition Initiative, cluster bombs. It is a form of munition. 112 countries do not allow cluster bombs. There's just many different nuances here that are very difficult to see unless you have it very, very fine-tuned. The 3x times which WRS testified before is extremely problematic. Our managers have said there in no way would adhere or manage our money if they had anything like that because of the uncertainty or the definition of what they view that they are. I apologize, of what they're looking at. So, in general, all of these, when we're looking at this and what we're trying to do, is there's no question that we are abiding by this for the state, for the betterment of the state's return, and that's true across the board. I know Representative Knapp mentioned about the state's income. Just to put a perspective on it, the previous comments that the WRS would lose 1.2 billion over 3 years, we're 3 times that size. So just approximately, you're looking at about $5 billion loss in income over the next 3 years. To put that in perspective, I'm on the CREG. The CREG has forecasted our coal revenue for the state over the next 3 years is $367 million. So yes, it's extremely important. We want to control it, but in a perspective, $5 billion is a significant amount of money and would limit our investments dramatically. So I tried to be really quick on that. I just wanted to give you a couple comments from what our managers, lawyers have said and how we feel and what we do to make sure that this is something that we abide by. I'd stand for any questions.
All right, thank you, Mr. Fleming. Any questions for Mr. Fleming? Seeing none, thank you very much. Mark, we have someone else.
Cecilia Herbert.
Ms. Herbert, we thank you for being on. I'm going to have to limit you to 3 minutes.
No worries. Thank you very much for having me. I won't repeat all the things that have already been said. I'm a member of the IFC. I'm currently the vice chair. I've been on it for about 4 years. I just want to sort of frame the discussion as the bill is very well intentioned, but I think as Representative Irrigans and Representative Lawley have pointed out, it delves so deeply into specifics that will be very hard to manage. And I think the result would be micromanaging the investment portfolios to the detriment of the state. Right now, the state treasurer's office, when it wants to add a manager, it has to go through a consultant, RVK. The IFC approves the manager and then recommends to the SLIB, who has the final approval of any new managers. So there's great scrutiny. As Kurt and Patrick have said, the investment policies that we already have in the state are very specific about no ESG, definitely exclusively pecuniary results on a risk-adjusted basis, and the results have been great. The permanent mineral funds over 3 years is the first performing fund in its peer group, and it's the 4th out of 14 in the 1 year term. So the results are great because in 2015 they hired a CIO. In 2017 they created the IFC. The legislator has broadened the available assets and the asset allocation. There's been asset and liability matching, and there's a professional staff. So the state is on the right track in terms of giving returns to the citizens of the state. And the returns that the state, the one thing that hasn't been said yet is that the returns from the state treasurer's office are 30% of the budget. So tinkering with this or micromanaging it is really not a great idea. And I'm not a legislator, so I'm not the right person to be tweaking the bills. But I think right now there's no risk that things are going off the rails because the investment policies of both the retirement system and the IFC, of the state treasurer's office are in sync, that there's no ESG focus. And I think we would lose great managers if we
Thank you very much.
Thank you.
We'll go on to Mr. Hild. 3 minutes.
Thank you, committee. I appreciate it. I will keep my remarks very brief. I know this has taken a while. I just want to clear up 2 misconceptions that seem to be going on in a lot of people's testimony about this bill. First of all, sorry, I should have introduced myself. I'm the executive director of Consumers Research, the nation's oldest consumer protection organization. And I'm concerned about ESG and how it raises costs for Wyoming citizens from everywhere from the gas pump to the grocery store. And one misconception that seems to be in the discussion of this bill, which I'm kind of baffled by, is it seems to be that people have the idea that Wyoming would have to divest from individual companies because they have taken a net zero pledge or because they have a net zero policy. That is not what this legislation does at all. It doesn't force divestment from individual firms. What it says is managers of Wyoming's money cannot be having made a commitment or made public pronouncements that they will use Wyoming assets to push an ESG agenda, whether that be net zero or pushing race and sex-based quotas on the boards of directors, like Larry Fink at BlackRock has said that they do and plan to continue doing. Really is only about managers, not about saying you couldn't invest. You can even invest in carbon recapture technology or sequestration technology under this bill. You just couldn't have a fund manager who says, my whole goal for managing your money is to push an ESG agenda. Second of all, there also seems to be a misconception about what ESG investing is, and that's intentional on the part of the people who support it. There is the ESG agenda where you make different investments based on ESG. You sell some things and buy other things based on ESG. That is a small portion of the overall phenomenon of ESG. The vast majority of fund managers pushing ESG are taking investments that do not have ESG on the label. Your index funds, for example, undoubtedly Wyoming owns S&P 500 index funds that are just the most vanilla investment you can have. If you have a manager who is committed to use all assets under management to push net zero, when he walks into corporate engagement meetings, he uses those assets that don't have ESG on the label to push a net zero commitment. And it's more than just the shareholder votes. It's these private, quote unquote, corporate engagements, effectively mafia shakedown meetings, where they threaten to vote against boards of directors, as they have done with Exxon, where they vote against compensation packages, where they have done with many other companies, unless the company will adhere to these political objectives of the investment manager. And I will just say, it's not academic, the losses. There was just a Fifth Circuit ruling against American Airlines, whose employees sued that company for using BlackRock, even though the company knew BlackRock was using those assets to push an ESG agenda. And they are calculating damages now. It could be in the hundreds of millions to that pension fund. So this is not academic. And I will just say, I'm so glad, glad to hear that Wyoming is in the top second percentile in their investment returns. That's excellent. It doesn't change the fact that because these ESG can be pushed with all assets under management, at the same time that Wyoming investments could be outperforming the market, their money could be being used to undermine the very industries that pay into that fund, namely oil and gas, cattle industry, the firearms industry. Those two things are not contradictory. Actually, it makes total sense. And lastly, I will just say that a lot of other states have passed similar legislation and have not seen the parade of horribles that has been trotted out here today, namely Kansas, Arkansas, Montana, Kentucky, South Carolina, Indiana, West Virginia, Tennessee, North Carolina, Florida, Utah, and Georgia have all passed similar legislation. Their funds are doing just fine. Plenty of people have walked in and been happy to take their business away from firms like BlackRock and charge similar fees.
Mr. Hill. Yep. All right, anyone else online? All right, we will close public comment, and we will carry this bill on to Monday morning and deal with that. We'll work it as a committee on Monday. So at that, we'll adjourn this committee for today and look forward to seeing you again on Monday.
What's that?